and so let's get started now. Nice to see you, everyone. And good morning, good evening, good afternoon, depends on where you are. Rachel Du and I will be, for today's session, I will be go through all the selected difficult questions from the quiz in the first 15 minutes, and then I will hand over to our panelists. Starting from the questions, let me share my screen with you. So the first quiz, I will only talk about selected questions, and if you have more questions regarding the quiz, please send me email your questions so that we can save time for panel discussion. The first question is, which description of the link between trade and sustainable development is not correct? The correct answer is number B, trade liberalization is always beneficial to achieve sustainable development goals. This is not true, that's why this is the not correct answer. And this is not true because trade and trade liberalization do not always contribute to sustainable development. There are some clashes, and that's basically why countries adopted trade restrictive measures to protect those non-economic interests. For example, we have import ban on flavored cigarettes to protect public health, and we've also seen ban on retreated tires to protect environment, and we've also seen import ban on products made by child labor to ensure labor standards. That's why promoting trade is not always beneficial to achieve sustainable development goals. I see over 50% of you have got the correct answer, so I will go to the next question. Question number 2. In FTAs, where deep sustainable development provisions can usually be found? The correct answer is number 3, in the dedicated sustainable development chapter. This is the correct answer because if an FTA has a chapter specially designed for sustainable development, it will have some comprehensive and deep sustainable development provisions. And I see many of you choose the answer preamble, but in preamble they are usually aspirational provisions which are not binding, and they are not deep, they are not comprehensive. So that's why they are not, preamble is not the correct answer, and general exceptions, they allow parties to take some measures, sometimes restrictive to trade, but are good to protect environment or to protect health, and is beneficial for sustainable development provisions. This is not deep. This is not deemed as deep because they are very basic components in both WTO rules as well as in the most of FTAs. And the last one, special and different treatment provisions, they usually refer to special treatment to developing parties in one FTA. So the correct answer should be dedicated sustainable development chapter. Next question is, which of the following statements is not correct? The answer to this question is number C. The ILO conventions require the use of trade restrictions to enforce compliance with the ILO binding standards. This is not true because the ILO conventions do lay down some labor standards, but it does not necessarily require the use of trade restrictions to achieve these standards. And many of you choose the answer, there is no multilateral trade rules related to labor standards, as labor standards are very much out of the ambit of the WTO. This is true, so this is not the answer to this question, because multilateral trade rules always refers to WTO rules. In fact, WTO rules do not cover comprehensive labor provisions. The only provision in WTO rules which is related to labor is Article 20E, and that is only related to the use of prison labor. And there is only one WTO declaration related to labor, and it just affirmed that the ILO is the competent body for setting and dealing with labor standards, and the role of WTO is just to support and collaborate with the ILO. So there is currently no multilateral trade rules related to labor standards. Next question. Which type of labor provisions is least likely to create binding obligations? As mentioned in the earlier question, that aspirational provisions in preambles, they are not binding, so they are least likely to create binding obligations. The rest of provisions are usually likely to create binding obligations, but in preambles, those aspirational provisions are not binding in principle. The next question, which of the following categories of labor provision has the strongest enforceability? The degree of enforceability, you can think it as a in this way as how strong the force is to ensure the implementation of provisions. So non-binding provisions are very weak in this regard because they do not create any legal obligations at all. And dispute settlement mechanisms are always useful to increase enforceability because they provide a means to address violations of obligations. And also, after dispute settlement, the result might grant the complaining party who wins the case the right to retaliation. That's why the more binding the provision is, and the stronger the dispute settlement mechanism is, the FTA would have the higher enforceability. That's why the correct answer is labor provisions that are binding and also subject to both state-to-state and private-to-state dispute settlement. These sort of provisions will have the strongest enforceability. Next question, regarding multilateral environment agreements, which statement is correct? The correct answer for this question is, in theory, FTAs that make references to MEAs is able to enhance the compliance with MEAs. This is the correct answer because multilateral environment agreements, they do not necessarily cover trade arrangements, but if FTAs make references to those MEAs, FTAs sort of incorporate these MEAs provisions as part of it, so that the compliance of provisions in the referred MEA actually will become an obligation under the FTAs. That's why it enhances the compliance with MEAs through this way. Next question is, which of the following environment-related provisions is legally binding? When we're talking about legally binding provisions, we always look at the word in the language the provision uses. The first one, recognizing the importance of blah, 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 anything. If we see recognizing the importance, that is an aspirational provision and is always not legally binding. And the second provision uses shall endeavor to maintain laws and regulations to comply with the environmental standards agreed under this agreement. Shall endeavor is also a non-binding language in FTAs, in provisions. And the next one, parties shall refrain from encourage investment by investors of each party or of a non-party by relaxing their environmental measures. The word shall here creates a binding obligation for parties to not relax their environmental measures. And the last one, parties may grant subsidies to environmental products. The word may is not as strong as the word shall, and usually also does not create any legally binding obligation under FTA provisions. The next question is, which of the following environment-related provisions has the weakest enforceability? So I just explained how to assess the enforceability of a provision. In this question, the correct answer is number C, recognizing the importance of strengthening capacity to promote sustainable development. So this is again an aspirational provision, usually can be found in preambles and does not create any binding obligation at all. So it has the weakest enforceability. Next question is, which approach should be encouraged when your country as a small island developing state is negotiating FTAs? So as a small island developing country or a small island least developed country, the protection of environment should be one of the priorities when you considering negotiate with other countries. So comprehensive and deeper provisions on environment protection is desirable, and they're needed for small island countries, while also incorporating cooperation and technical or financial assistance mechanisms is always help for capacity building. So that's why number D, incorporating strict environmental standards along with cooperation and technical or financial assistance mechanisms is the best choice for small island developing or least developed countries. I think we've finished. That's it for the quiz part, and if you have any other questions, please just email me and I will always reply. So to save time, let me hand over to the moderator of panel discussion, to Mr. Jan Duval, and hand over to you, Jan, please.
Thank you. Thank you very much, Rachel. Good afternoon. or good morning, maybe to all the participants here. Thank you very much, Rachel, for going through some of the quiz questions. We had a little bit of a technical issue at the very beginning, but not to worry. For those who joined us a bit after the session, beginning of the session, everything is being recorded, so you can always, if you have questions on the quiz, you can always go back and see what Rachel explained at the very beginning. So on that note, maybe let's move to the panel session, and we are very lucky to have very senior experts with us today to discuss some of the different topics related to sustainable development in regional trade agreements. This is really a topic that is becoming more and more important, and that explains also why I think we have about 220 or 230 participants taking the course. You all know that the COVID-19 crisis created a lot of stress on the international supply chains and on trade over time, and this is what started at ESCAP we started at ESCAP a lot of the work on trade negotiation and regional trade agreements. We realized that despite a very large number of regional trade agreements in place among the countries of Asia and the Pacific, I think it's about 200 or 200 plus at this point, regional trade agreements. I mean, trade in some cases came to a stop because of the COVID-19 crisis. So this started us wondering, what's the design of those regional trade agreements, and what should we improve? Should we find ways to improve the design of the regional trade agreements so that trade can still flow, especially trade in essential goods can still flow during crisis? And so now we are at the stage where the COVID-19 crisis is over in most countries, and so now the idea is, how can we build back better? How can we make trade agreements really foster sustainable development, inclusive development, sustainable development, environmentally friendly development? And this is why we started developing this course with Paul Baker, who is the first speaker in the panel here, and I think many of you have seen his face because I've seen you because you've watched the videos, right? And so I think his face is on all the videos, at least the first few minutes of each of the modules. So on that note, I mean, I think let me invite Paul to give an introduction on sustainable development provision in RTAs, and maybe tell us a little bit more about how to assess the impact also of the sustainable development provision in RTAs, because this is always something that comes to mind, right? Is that, okay, let's add text to regional trade agreements for sustainable development, but is it useful? What's the impact, and how much should you add? And depending on what country, your country situation, does it make sense to go for environmental provisions or labor provisions or both, or so on? So Paul, your reflection on this, and you have, I think, 15 minutes at the most at the beginning, and then we'll have plenty of time for Q&A after all this panelists have spoken once.
Thank you very much. Thanks, Jan, for the introduction, and pleasure to be here as well with all of you. And I'm impressed indeed by having 230 participants that have followed the course. That really is truly an amazing amount of students in such a short period of time. Hopefully I saw from the responses in the quiz that around at least half the people understood most of the questions. So that's some hope, I think, for going forward. And just to perhaps say that the way we looked at it is very much more from sort of a legal interpretation of the agreements. That doesn't mean necessarily that the agreements themselves are not friendly towards sustainable development. And maybe, as Jan said, just to try and deviate a bit from the introduction I gave in the first workshop, or the first training module, I will just also talk a little bit more about the implications of what these provisions have in FTAs. So just moving on to the second slide, just as a quick reminder again that sustainable development has emerged from this field of environmental sciences, and it's a way of trying to bring together these different spheres of human development, the environment, and also social development. And of course, I mentioned in the first module that it's defined by the former World Commission on Environment and Development as the development that meets the needs of the present without compromising the ability of future generations to meet their own needs. In addition to that, the EY came out with a report last year that states that sustainable development is exchange of goods and services that can generate social and economic and environmental benefits, which go beyond the creation of just purely economic value. And I think, you know, seeing it couched in those particular terms is quite important. So sustainable development has these three pillars of environment, economy, and social, and they are mutually reinforcing, and they are quite interdependent as well. And so this was this graphic, I think, captures quite well how these different dimensions actually also deliver on the viability and sustainability of the agreement, the equitability of agreements, and how we can live with these agreements longer term. Just to say that also, as things are evolving, and we also see the FTAs and the languages in FTAs and the scope and ambition of FTAs has evolved over time, so has also the definition of sustainability. And so we're increasingly integrating things like human rights, women's empowerment, gender equality, access to education, environmental safeguards, disability rights, and you know, many other aspects are evolving to be integrated into trade channels over time. And really spearheading this are the European Union, Canada, Australia, New Zealand have been some of the countries that have been the most forthcoming in terms of generating some of these different types of agreements. I just leave you with a little quote at the bottom here, which I thought was quite interesting, from the Ministry of Foreign Affairs of the Netherlands. It's a little old now, the document, but the idea is again to try and promote trade and production processes to bring economies a step closer to realizing sustainable development goals and avoid a race to the bottom. And you will see that actually some of the development provisions that have been incorporated in FTAs actually very specifically try and target this avoidance of say lowering your environmental standards or your labor standards to try and attract or promote investment in your jurisdiction. So they actually prohibit that from actually occurring. And I think what the Ministry of Foreign Affairs of the Netherlands was saying, that again, we need to make our trade agreements also ensure that in the way of competing for resources, we don't end up compromising you know, environmental or labor integrity. So we do make, you know, quite a big deal in terms of how trade policy can actually interact with different many of the different sustainable development goals. So, for example, through different non-tariff instruments like TBT, sanitary and phytosanitary standards, but also voluntary sustainability standards. And, for example, responsible business, which is in the voluntary sustainable standards category, is actually now being integrated into some FTAs. We had a question regarding technological transfer as well, which goes you know, beyond just traditional trade instruments. That's also being incorporated into FTAs. And according to UNCTAD, they came out with a report called Better Trade for Sustainable Development report last year in 2021. They state that around 41% of non-tariff measures actually work towards achieving these particular SDGs. So while, just to say that while there are no specific trade SDGs that have been articulated, they are the different trade aspects actually contribute to these SDGs, and particularly we see, for example, within SDG 17, quite a strong alignment between how trade can actually improve the well-being of many of the poorest countries in the world through these preferential schemes to enable them to have better access to markets. Just one last issue, though, with the SDGs that has been criticised is that they very much focus on the export aspect rather than on the trade aspects. And so it doesn't always address some of the more critical problems of being able to integrate into global value chains. And it doesn't address some of the other problems related to governance and transparency as well. So while international trade does have several considerable implications for the environment and society, it also has many opportunities for sustainable development to contribute towards, say, poverty reduction, job creation, innovation, improving job security, gender equality, and workers' rights. In the United States, for example, there was a study carried out on the environmental goods and services sector, and they estimated that the low carbon segment of that market contributed around $1.3 trillion of revenue and created up to nearly 10 million jobs. Despite the obvious, perhaps, interaction between labour, environment and trade, economists tend to be actually quite critical of integrating labour and environmental provisions into free trade agreements. They believe that that's the second best option. These can be trade distorting and they can be welfare reducing, despite the positive effects that they have, just because the best instruments for dealing with the environment and labour are environmental agreements and labour agreements. Obviously, the reason why they are being integrated into FTAs is actually the implications and the impact that it can have if you actually don't fulfill your obligations in the environmental agreement. There will be actual trade implications or investment implications that will result from that. So they're increasingly being integrated into these agreements, as the WTO is also being used as a mechanism for settling disputes globally. These FTAs are also being introduced, these provisions are also being introduced into FTAs to try and address some of the conflicts that arise between different countries in terms of how environmental or labour laws are being applied. And I'll give a couple of examples how some recent agreements have been using that. There's a very, very large literature about the contribution of trade to sustainable development, and there is quite a strong disagreement in the academic community really about the direction that the impact can have. Obviously, it can be welfare augmenting, it can lead you to get access to more sustainable technologies and goods and services that will actually help you become a more sustainable country. At the same time, of course, it can also lead to exploitation and depletion of natural resources too. And so many of the agreements try and cater to deal with these particular issues that might arise, or they become stand-alone agreements that are attached to the free trade agreement. So the European Union, for example, has bilateral fishery agreements that are renegotiated on a twice-yearly basis with countries to ensure that the marine stocks are not depleted unduly, despite having a very strong trade emphasis that promotes trade in marine products. There are many side agreements that also incorporate this development aspects of FTAs. Just to say that, of course, different countries have different reactions to how the FTA will impact them from a social or environmental perspective. And so actually some countries, what the observation has been is that lower income countries or middle income countries have tended often to weaken regulations to try and attract companies to set up operations in their country. And that can have obviously quite strong negative social implications for those countries. So what we have seen, and we discussed that in the course, is that North-North agreements tend to be much stricter in terms of the provisions that are incorporated into the FTA than, say, North-South, and particularly South-South agreements are still quite rarely actually introduce many restrictions as to how you can actually operate in the environment and labour spheres. Here is an example of some of the sort of quite important prominent agreements that have been recently discussed in the sustainable development literature. The CPTPP, of course, is seen a bit of as a landmark agreement in terms of the sustainable development chapters that it encompasses. And so here is just looking at what scope is covered. It's not looking at the depth or the enforceability of the provisions, but it's just saying whether there is a dedicated chapter to these issues. And so we see that the CPTPP, incorporates environment, labor, SMEs, and responsible business chapters. So it tries to ensure that there is strong enforceability of different provisions to try and safeguard development aspects related to those different areas. The UK-Singapore Digital Economy Agreement incorporates labour and SMEs, for example, and also has quite a strong development chapter. The UK EU TCA incorporates, for example, human rights. It's the only agreement that's listed there to incorporate human rights. And of course, one of the reasons for that is that the UK would no longer be bound by the European Court of Justice, although there was discussion around it not being bound by the European Court of Justice, and the EU wanted to ensure that the UK would actually still abide by human rights different commitments. So we see PASA Plus there, which is quite surprising because PASA Plus is the New Zealand, Australia, Pacific Island Agreement, which is considered as a very development friendly agreement. But what you'll see is that it doesn't actually have any development chapters, or the more traditional development chapters that we would expect. And so we have to be a little bit careful with the course, because it's really looking at the specific provisions that are incorporated into it, not necessarily some of the side agreements, nor is looking in depth into the development cooperation or the institutional frameworks that have been established as a result of the implementation of the agreement. And PASA Plus has a very, very strong development friendly outcome, but that's not because the agreement itself is forcing the parties to do so. It's actually being the political alignment of the different parties to try and make this agreement as developmental friendly as possible. But if you just read from the legal perspective, you just read the different provisions in the agreement, you would conclude that actually the PASA Plus appears to be relatively weak. But as I say, that's not necessarily how the outcome of this takes place. So just to sum up, most of the sustainable development provisions that we find in RTAs are still considered fairly weak in terms of enforceability, but also generally in language. It very much rests on the development cooperation provisions in many cases, as well as the kind of institutional framework that will be established through that. Some FTAs exclude S&D from dispute resolution mechanisms. So that means that if there is any conflict, we don't actually have any mechanism to actually enforce it. And others, in the case of having dispute resolution mechanisms in place to settle any sustainable development disputes, the legal binding nature of the dispute settlement report is not clearly established. So we will have a panel that will deliberate on the conflict, but it isn't clear how the decision of the panel actually gets implemented. And so I think we've tried through the module to explain that quite well, that we still have to be quite careful in interpreting how effective these decisions can be. There are a lot of aspects related to trade that sometimes fall outside of these sustainable development provisions, and yet they can have a very significant impact on sustainability. So here we talk about, for example, trade facilitation and trade digitalization. An ICC report from last year, and I think this is also part of the work that ESCAP works on, has estimated that if the trade ecosystems were fully digitalized, it could reduce trade costs by as much as 84%, and that obviously would have very big implications for the SME sector. Other actions in FTA agreements that can also make a big difference is addressing informal trade, and here African countries have been more successful than others in terms of trying to incorporate provisions around informal trade and facilitating trade for the informal economy, for low value trade. Also inclusiveness provisions, gender mainstreaming. Surprisingly, for example, under the CPTPP, there is no specific gender provisions, but of course there are labour provisions that will impact on gender, but we don't find a gender mainstreaming chapter specifically under the CPTPP. And then other capacity building elements, of course, can be quite critical as well. I think it was quite emphasized as well in the module, but if we want to make FTAs really impactful, we need to see how the institutional framework for monitoring the agreement takes shape, and what kind of corrective actions can the committees do to try and improve the sustainable development aspects of the agreement. And that, of course, demands quite strong political will, but also quite strong political capacity. And just my very final slide that I'll leave you with here is something not said by me, but I think it's been reiterated by me in other ways, is really that to have a real impact, you really need to support the implementation of the agreements through very effective and well-designed governance mechanisms that can actually make trade much more sustainable in the future. So I'll leave it at that, and of course happy to answer any questions, Jan, as they come up afterwards. Thank you.
Thank you very much, Paul. I think your presentation really adds value to the modules that the participants have gone through. So thank you very much for this. You may know that Paul Baker is actually an economist rather than a lawyer. I mean, you correct me, Paul, always if I'm saying something wrong. I'm also an economist rather than a lawyer. And so, I mean, for us, we always see thinking about, what is the impact? How do you measure the impact? And so, and I think it's very important. One thing I learned, right, by also supporting organization of those courses is that it's very important, I think, to bring the lawyers and the economists together because both aspects are very important. If you look at the literature, actually, you really have papers that focus only on the text, on the legal aspects, and then some papers that only focus on the impact. And then sometimes you wonder whether those people actually talk to each other, right? So I think I encourage everyone because I think most of the participants in the course more have a legal background and economic background. Maybe take a look at the handbook, the ESCAP handbook that Paul also wrote on sustainable development, negotiating sustainable development provisions in RTAs. It goes beyond what is in the video modules, and look also at provide some basics on how do you assess the impact of RTAs, including sustainable development impact. Taking I think a page of the methodology from the European Union, because the EU has been very active in pushing for sustainable development provisions in RTAs generally. So thank you again, Paul. I invite everyone to type questions to Paul in the chat, and then after we've gone through all the presentations, we'll come back to the entire panel, and Paul and others can answer. So on that note, maybe let me invite the second expert in today's live session, Mrs. Marva Coulibaly. She is the chief of the Globalization, Competitiveness and Labor Standards Unit of the ILO, the International Labour Organization. So I think it's very difficult to find someone better and more qualified to speak about labor provisions in FTAs at this point. She also teaches at the Graduate Institute at Geneva, I think, on that topic. And so we're very pleased to have her with us today. Marva, you've got the floor.
Thank you very much, Jan. And yes, it's really a pleasure to be here. And I would say, in fact, that actually it's a tall order to go after Paul. He was quite comprehensive in his presentation. So, and I have the impression that the participants in the course have been learning quite a bit during the week. So I expect a number of questions to challenge some of my thinking. So I hope that I can have a good value added here. As Jan mentioned, I am the chief of the Globalization Unit at the ILO's Research Department, and we've been working on these issues of labor provisions, I would say, for the past 15 years within my unit. And I'm going to present to you some of our thinking on this that has evolved a bit over time, as well as a little bit in terms of the research we've been doing, and introduce the Labor Provision Hub, which is a nice intersection, the research and labor provisions hub of this entire legal, economic dimension that we've been talking about. So first of all, I think it's a good idea to get definitions out of the way. And I don't know the working definition that you've been using in the course, so I'll present the one that we have from the ILO, and that seems to be the standard in the literature at this point. So we call it a definition based on 3 C's. It's quite memorable that way. So you have a commitment, first of all, in terms of the commitment towards a principle or standard or rule, which relates to labor relations, minimum working conditions, terms of employment, or other labor issues, including with respect to international labor standards. And of course, I'm going to jump to the other C, which is compliance, which is the last one. So you have the commitment, and then you have the compliance with respect to that commitment. And that compliance is any mechanism to ensure compliance with the standard or the issue either that's set under national law or within the trade agreement, because some of the compliance is specific to the trade agreement. And then the third component, which is cooperation and dialogue, which is an extremely important component of the third C, which falls somewhere in between. It's a framework to promote compliance with labor standards. And this can be done through cooperative activities, dialogue, or other types of monitoring of labor issues, either within the trade agreement or separate from the trade agreement. So with that definition in mind, based on our latest information at the ILO, we find that there are 113 trade agreements that have labor provisions. So that's about 1 out of 3 trade agreements. And you can see by the red line in the figure here to show the increase over the past, I think that's 30 years, and that half of these labor provisions and trade agreements came into existence only in the last decade. So between 2011 and 2020. I won't go into the reasons for that here. I mean, but of course you can understand part of it has to do with, especially from since 2008, as part of it has to do with some of what's gone on in terms of the multilateral system, and the main proponents of labor provisions, as was discussed in the previous presentation, insist in this in terms of their trade agreements in general. And I always like to say that it seems to come to a point where it's not a matter of if labor provisions should be in trade agreements, but a matter of how you include those labor provisions. And it's not a matter of if they shouldn't be included now, but a matter of when, in terms of countries that don't have labor provisions, when that time will actually come. And so just quickly, why is that the case? And it's for 2 reasons. The first one, from a worker's perspective, and this is something that was mentioned a bit earlier, having to do with the race to the bottom. And so that's mainly addressing these governance gaps that you see as a result of trade, and mainly this proliferation of global supply chains as well, to promote workers' rights and international labor standards in these sectors where we see decent work deficits exist. So where we see instances of child labor, forced labor, as well as lack of freedom of association in some of the tradable sectors, which one would maybe refer to more of the worker from a worker perspective or moral perspective as well. But from a firm's perspective, there's also a very strong reason, and that's to level the playing field between trading partners, so that there are these rules that are in place for tradable sectors, for firms engaged in tradable sectors, so they're not able to compete based on violation of, in this case, international labor standards, or in some of the other cases with sustainable development, some other issues that might ensure that countries have or sectors have lower wage costs, but that these wage costs are based on violation of certain rules that are in place. And what are these obligations? Most of the trade agreements, these obligations are aligned with ILO instruments. And what do I mean by that? It's about 2/3 refer to the ILO's fundamental principles and rights at work, which promotes freedom of association, elimination of forced labor and worse forms of child labor, as well as discrimination in the workplace. And these are, by nature of the membership to the ILO, these are principles that members already agree to. So in some sense, one could argue that labor provisions in trade agreements, by including this language, provides no further obligations to states than those that they already make as a member to the ILO. However, some go further and make a reference to ratification of all ILO fundamental conventions, which is not a requirement at the ILO. And 35% of trade agreements actually have that obligation. Some also refer to the ratification of ILO priority conventions and other principles that you see here in the figure. But I want to get to an important question, which I think may be a burning question in many folks' mind when they think of labor provisions and trade agreements, especially from a trade perspective, especially from a firm's perspective, and which has been one of the main reasons why there has been this reluctance on the part of many states to include labor standards in a trade framework. And that question is, does compliance with labor standards reduce firms' competitiveness and adversely affect trade? It might be interesting to put what your answers are in the chat. I don't have my double screen, so I can't see the chat box at this point, but I think it's always an interesting discussion to have around this in terms of what the perception is and what the evidence actually shows. So I'm going to maybe not give you a minute to think about it, give you 2 seconds to think about it, and then jump to the next slide, which is some evidence that we've been working on at the ILO, and then to show you some evidence from the literature. So we did a publication in 2016, and this was one of the principal analysis in the publication to understand the extent to which labor provisions and trade agreements reduce or divert trade. And this is a whole argument surrounding protectionism, that labor provisions are being used for protectionist reasons in order to raise the costs of doing trade and thereby to erode the comparative advantage of developing countries. However, in our study, we did not find that to be the case. In fact, that we found that trade agreements with or without labor provisions boost trade to the same extent. And that was whether over different periods as well. So we analyzed it for both a 20-year period and then taking into consideration a smaller period of 10 years. And we haven't updated this research, but other studies have. And other studies, such as one recently in 2021, have found the same results. And those results stand whether you dissect labor provisions by those that have stronger enforceability and those that have weaker enforceability. The results stay the same, even for trade agreements that have labor provisions with what we refer to as strong enforceability. And on the contrary, if you look at studies in the literature, it finds that, in fact, core labor standards boost productivity and profitability of firms because investors or those foreign, in terms of foreign direct investment, searches for areas where there is a support for labor standards and searches for areas where they know there won't be issues with respect to violations of labor standards in general. And one can find this in the studies that I've referenced here. And I would say, moreover, in terms of evidence of protectionism, this has been analyzed in the literature more broadly, and there hasn't been found any evidence in terms of labor provisions that there have been any differences in compliance among countries to insinuate that they're being used in such a way to try to falsely reduce trade. And we also recently at the ILO did an analysis of all the submissions. These are the complaints, violations that were submitted in the context of labor provisions and trade agreements. And we not only did we not find that any that were reviewed could be considered for protectionist reasons, but we also found that over 80% of these submissions were actually submitted by individuals within the violating country, which suggests that they're not only a tool or not specifically a tool for cross-state violations, but for workers having voice within the specific country. And the last point I'll make is something that was alluded to earlier as well, and maybe this was an argument, in fact, for the weakness of the system around these sustainability provisions. In fact, these are dialogue-based mechanisms. Even when there's strong dispute mechanism in place, even when there's a possibility of a sanction in a trade agreement, this is rarely used. In fact, sanctions have never been put in place in the context of trade agreements. And there's only been one case that has gone to arbitration and one case in which a panel was called, and that was the case of EU-Korea in terms of the panel, and US-Guatemala in terms of going to arbitration. And the case of US-Guatemala, in fact, many of you may already know that it was found in favor of Guatemala. So I'd just like to at this point stress the importance of this dialogue-based approach for conflict resolutions, which regardless of whether the literature categorizes labor provisions as conditional or promotional, in both cases, they're actually dialogue-based. And maybe the last slide here that I'll mention, because I was asked to keep the presentation short to make room for other presentations as well as for Q&A. I'd like to show how we go from these 3 C's of the definition to what we call the 3 pillars of labor provisions that we use as the basis for the Labor Provision Hub, which I'll show you very quickly just over the next couple of minutes. So first of all, we have, as I mentioned, the 3 C's of commitment to the obligation, compliance with the obligation, and the cooperation and dialogue that takes place in order to promote compliance to the obligation. Within that, we broke it down, the chapter, whether the labor provisions are in the chapter, a specific labor chapter, a trade and sustainable development chapter, an MOU, or any other way, or even an investment chapter. We separated or categorized the labor provisions according to this typology here. So the obligations refer to the commitments under cooperation and dialogue. There are these institutional mechanisms that are put in place in trade agreements that enable dialogue to take place and that help to ensure cooperative activities as well. And in terms of compliance, we all know that as dispute settlement. And of course, there's a wide spectrum of the language, I saw that mentioned previously in the quiz, of the language that's used in trade agreements with respect to labor provisions as well, in terms of either shall or will, and should or shall, I should say. Those are the main words. But we don't make that distinction in the database. So this is a Labor Provisions and Trade Agreements Hub. It's on the ILO's website. I would invite you to visit it. I won't go through a demonstration here. It's really just to show to you the information that's available in the database. The 3 pillars that I was talking about, labor provisions are categorized by obligations, monitoring, let me see if I can reduce this here. It's already reduced. Okay. Obligations, domestic labor laws, international conventions, international declarations. Under monitoring and cooperation, it's also separated into different areas. There's a map function. Let me just reset filters for a minute. So as you see here, there are 354 regional trade agreements that are reported to the WTO. Out of the 354 trade agreements, there are 113 with labor provisions. You can also do a trend graph to show, this is a figure basically that I showed you. And you can also, this is the last thing I'll show you before I conclude, you can also search by trade agreement. I heard that you've been talking a lot about CPTPP. Let's go back to the map. And if you wanted to search CPTPP, to show the different information that's in there. You can search by any area. And I heard it was mentioned something like it's gender is not included or anything. There are no gender provisions in TPP, and that is the case. However, there is a mention of something with respect to women. It's not a gender provision, but so if you do a search of women, open this up a bit, you can see that there are some cooperative activities with respect to women in the trade agreement. And the database gives you the opportunity to search applications, to search in particular thematic areas over time to see the evolution, and it's based on the legal text. So I invite you to take an opportunity to, take a drive around the database and let us know what you think. Just one last thing. There is a video here that if you click on the video, it will give you an overview of the database and to help you to navigate through it. So I think I'll end here and answer any questions that become available later. Thank you very much.
Thank you very much, Marva, for your presentation. I actually put the link to the beautiful website that you have on this. I mean, it's very impressive and it's very comprehensive and it's very new too. I think it's 1 month old.
It came out at I think we launched, we were supposed to launch end of January, maybe it was early February, but it's a couple months old. Okay, new baby, it's a baby.
Yeah, so many people still don't know about it because every time I share it, people are happy that I share it. So I guess they didn't know. And we do share it from ESCAP side because it's a very valuable product. One thing I wanted to repeat again, right, is I think your comment that labor provisions, it's not a matter of whether labor provisions should be included in trade agreements. It's in what form or and how to put them in. And I think this is becoming even truer by the day, right? I was reading an article about the US trade policy, right? And obviously this is going to affect everyone. And I think they talk about now their worker-centric or worker-sensitive trade policy, right? And so that's really a very, very big shift in some of the trade policy making that is happening in some of the large economies and developed economies. And so I think it's not going to be an option anymore to have labor provisions. It's also very good to see that whatever research has been done show actually that the labor provisions don't reduce competitiveness. This is one of the questions that actually was put by one of the participants, was sent by one of the participants before. So it's very good to hear that there is evidence that there is no negative linkage because some people have been arguing this. All right, so please, participants, now we are reaching a pretty big number. We have 100 participants, so I think we solved our technical issue. If you have questions for Marva, please put them in the chat and we'll go back to Marva at the end. And please specify that the question is for her. So on that note, I'm moving to the next presenter and expert that we have today. Her name is Mrs. Michelle Limenta. She's an associate professor of law at Universitas Pelita, Harapan, UPH. I hope I'm saying this correctly. And she's also the director of the UPH Center for International Trade and Investment. And then we came across Mrs. Michelle Limenta name because she just published a paper on that very topic of sustainable development provision in RTAs. And I understand that she actually attended an earlier version of the course that we organized last year as well, as she was writing the paper. So we said, okay, we can't do this live session without her. So let me give you the floor and then provide the perspective from Southeast Asia and from Indonesia perspective in particular. Go ahead, Michelle.
Thanks, Jan, and for inviting me to this online course and discussions. It's such an honor indeed to share this session with distinguished speakers like Marva and Paul. Let me share my screen. Yeah, so my presentation today focuses on trade and sustainable development in particular environmental protection in ASEAN future FTAs. It's quite specific because when I received invitation, the tentative program, I saw there's another speaker that will talk about environmental protection in FTA. So that's why I think to not conflicting, so I go a bit specific by looking on Southeast Asia region, the FTAs, and why the future I will explain later on. So this is still my ongoing research, so I also look forward to any input, comment on how I can also develop this research. So as Paul mentioned earlier, and I believe we all aware that today we see increasing numbers of free trade agreements or FTA that go beyond traditional reduction of tariff by covering a wide range of policy areas, including environmental protection and labor, human rights, and so on. And for environmental provisions in FTA itself, the scope and the depth vary from just being mentioned in the preamble to providing detailed provisions in the dedicated chapter on trade and sustainable development. Among countries and economies, we see Canada, the European Union, the United States that have included comprehensive environmental provisions in their FTAs. But not all countries and economies that follow this approach. Australia, for example, as you can see here, I took from Guardian, the news, this piece of news. Australia, for example, takes the position of separating trade and sustainable development, trade and environmental issues. So that's the position that separating trade and environmental issues. Indonesia, my country, so far we have a trade agreement containing environmental related provision in the sector of energy and mining, namely Indonesia-Japan Economic Partnership Agreement, EPA. Here, under this agreement, the parties, and I quote, confirms the importance of avoiding or minimizing harmful environmental impact of all activities related to energy and mineral resources in its area, unquote. Indonesia also have another trade agreement containing a dedicated trade and sustainable development chapter. That is Indonesia FTA CPA, Comprehensive Economic Partnership Agreement. So at the ASEAN level, ASEAN eagerness to include trade and sustainable development chapter in their FTA for now seems to be low. The sustainability elements in ASEAN FTAs, such as ASEAN Australia New Zealand, ASEAN China, ASEAN Hong Kong, and the recently entered into force RCEP, they are limited to general reference in the preamble or general exception clauses. None of ASEAN FTAs contain devoted sustainability-related chapters such as labor, environment, or trade and sustainable development. So the question is, does ASEAN exclude or separate sustainability aspect from trade or economic concerns? And another question is, do ASEAN instruments and structure include the aspect of sustainable development or not? So before we answer these questions, it is important first to understand ASEAN and its instruments, which I believe you may familiar with. But let's go. I want us to go to look at together briefly ASEAN journey in becoming a community. So the ASEAN, the Association of Southeast Asian Nations, founded on 8 August 1967 by means of the Bangkok Declaration signed by five foreign ministers of Indonesia, Malaysia, Philippines, Singapore, and Thailand. In 1980s and 1990s, ASEAN membership was expanded, joined by Brunei, followed by Vietnam, Laos, Cambodia, Myanmar, and Vietnam, Laos, Myanmar, and Cambodia. Cambodia is the last one. In October 2003, the Bali Concord II was endorsed, stating that ASEAN community will be established consisting of 3 pillars, which are political and security cooperation, economic cooperation, and socio-cultural cooperation. In December 2005, the ASEAN leader issued the declaration on the establishment of the ASEAN Charter, which the declared aim of the Charter was to create the legal and institutional framework for ASEAN. And this charter was adopted in November 2007 and came into force in December 2008. Another milestone for ASEAN was the launch of the ASEAN community based on 3 pillars in 2015. Back again, to say ASEAN is totally agnostic to the notion of sustainable development is, in my opinion, is not quite right. The preamble of the ASEAN Charter is clearly states that ASEAN members' commitment to ensure sustainable development for the benefit of present and future generation. So, and if we can see also from this table, sustainability aspects such as environment, labor, they are included in the as the elements of ASEAN socio-cultural community pillar. And if you see here, sustainable management of biodiversity, natural resources, sustainable climate, sustainable consumption, production, and environmentally sustainable cities are the characteristic and element of the ASEAN 2025 Socio-Cultural Community Blueprint. Also, other social issue of concern, such as poverty eradication, women and gender, they're also part of ASEAN socio-cultural community. But also to argue that ASEAN excludes sustainability aspects from economic concerns, in my opinion, also not quite right. You can see here the ASEAN Economic Community Blueprint 2025. ASEAN recognizes the important role of sustainable economic development in for the regional growth. And the Sustainable Economy Agenda under the ASEAN Economic Blueprint 2025, you can see here appears to focus on environment, such as green energy, the protection of natural resources, and sustainable forest management. And so besides these ASEAN instruments, we also see in the recent year a growing number of ASEAN members, Philippines, Indonesia, Singapore, and Vietnam, have concluded a bilateral trade agreement containing a chapter on environment, labor, and also this in specific trade and sustainable development chapter. So what I want to highlight here and in my future research that these relevant ASEAN instruments, together with certain ASEAN member states bilateral free trade agreements, could present important modalities that could be used by ASEAN members as a bloc when negotiating FTAs with third country in the future. So here I highlighted some potential coverage and elements that could be considered. First is about the inclusion of sustainability elements or commitment in the preamble. This type of inclusion you can see in the ASEAN Charter and is already adopted in several ASEAN FTAs such as ASEAN Australia New Zealand, ASEAN China, ASEAN Hong Kong, and the RCEP. And also, it can be considered about the element of reference to international agreement related to environmental protection. So the MEA, multilateral environmental agreements, such as Convention on Biological Diversity, the United Nations Framework, Convention on Climate Change, in which all ASEAN members are the parties, these conventions are likely to be accepted to be referred in the FTA. In practice, even these MEAs are explicitly referred in Philippine FTA, Indonesia FTA, EU Singapore, and EU Vietnam FTA. And the third is about the possibility of our specific protection sector, environmental sector. Here, I just give an example that it's possible to consider about forest management. So this forest management could be a sector or area of interest to be included. The Southeast Asia region, as we know, is a home of nearly 15% of the world tropical forests. But the region is also known for the rapid increase of deforestation. So ASEAN members have a huge interest in in protecting their forests, and this interest is stated in the vision and strategic plan for ASEAN cooperation in food, agriculture, and forestry, where promoting and achieving sustainable forest management is one of the key stated objectives. So, and sustainable forest management is already agreed in Indonesia FTA, CEPA, EU Vietnam FTA, and manual trade in forest product and timber products already agreed in Philippine FTA, EU Vietnam, and EU Singapore FTA. So I close with this presentation with the other elements that that can be considered, which is enforcement mechanism. So so far, the mechanism that might be acceptable for the ASEAN is expert consultation or consultation within a joint committee with the objective to achieve a mutually acceptable solution of the matter. So for the TSD chapter to fall within the formal dispute settlement, for now might not be feasible from the ASEAN side, considering ASEAN approach to state-to-state dispute settlement. So I end my presentation. I look forward to receiving any input, comments, or question from all of you, and I thank you for your time. Thank you.
Thank you very much, Michelle. I think this is very timely presentation because I know that ASEAN is now updating it's the ASEAN Free Trade Agreement, right? They're starting negotiation on this, and the idea, yes, is to include more sustainable development provisions. I think some of the information that you provided here, some of the thoughts would be directly useful to some of the trade negotiators. If anybody has a question to Michelle, you can also put it in the chat, and then I'll give a few minutes to all the experts who spoke to respond, right? So I'm guessing we received quite a few questions, right, in the chat as well. So it's going to be, we only have, according to the official time, right, only 5 minutes left. So we can go a little bit beyond time if necessary. But I'm going to start by asking Paul to respond to some of the questions that are in the chat, and some of those that are also were sent in advance, right? And one of the one that was sent in advance was, and I'm reading it, right? Am I right in saying that since enforceability is a degree to which a provision is binding, non-binding provisions have no enforceability? And so this issue of enforceability, I mean, comes through many questions, right? People say, okay, what's the point to engage to have sustainable development provisions since anyway we cannot enforce them, right? So can you please provide some explanation on the connection between the degree of enforceability and the World Bank's categorization of provisions, which I think is used in your videos, right? And the categorization of provisions in the World Bank is whether provisions are not there, are shallow, or are deep. So if you could highlight, I mean, give us a short answer on that. And then if you've seen some other questions addressed to you, I've noticed that you've written responses in the chat, but if you want to address any of them, you've got, let's say, 3 or 4 minutes to do so.
I'll try my best, Jan. Okay. Yeah, no, on the question you just read out, indeed, if we just look purely at the language, we can see that some of the non-binding provisions actually have very little or no enforceability at all. But again, as I mentioned, it's really about the implementation of the FTAs. And I think that's what's quite nice actually with, and I wasn't aware of the ILO database, so that's very nice that you've shared it, but you're looking at different dimensions and not just purely the provisions, you're also looking at the monitoring evaluation mechanism and the institutional framework. And I think that's what is missing, perhaps, if you just take a purely legal view of it. But it is also true that if you cannot actually enforce any disputes, and if you cannot introduce any sanctions or penalties, then it does become problematic, and it just relies on the goodwill of the different parties. And so it works perhaps amongst some parties, but it wouldn't work with others. Just on the World Bank, the trade agreements methodology, you can actually find the methodology online, and it's an 18-chapter document. It's rather long, and each of the chapters in the methodology explain how they've come up with their scoring system. So, for example, with regard to the labour market, I think it's Rice and Sari are the authors, and they describe shallow provisions as including just aspirational statements in the preamble or the objective sections, while a comprehensive or a deep provision covers much more substantive commitments, which are found in the main text. And one of the criteria is that the location of the provisions within the FTA itself. For the environment, similarly, a deep provision consists of an item that is described in a substantive way in one of the chapters and might be subject to enforcement as well. So the enforcement mechanism is also considered in some of the ways that they look at some of the chapters of the FTA. So it's quite complicated the way they look at it, but I think the essence of what they do is very similar to the way we actually looked at it as well in the course. So it doesn't change that much. I did try and answer some of the questions that were in the chat. I just saw one with regard to HS. So somebody would like, I think, to do a little bit of econometrics around how impactful these provisions are, and whether we have the provisions against the HS codes, which of course would be very valuable. But we don't. You would obviously, if you have a specific provision, say around FLEGT, which is around forestry products, then you could associate that provision is specific to those particular products, but you'd have to do that work yourself. I haven't seen it in a trade agreement itself where they are actually looking and provide the HS codes to which the provisions would apply. And usually they're much more cross-cutting, right? So the labour provisions cut across all different sectors and all different products. So I haven't seen anything useful in that. And I'm happy to yield, but if I miss something out addressed to me, I'm happy to come back on afterwards. So yeah. You're on mute, Jan.
There was a question on are FTAs a suitable forum for addressing human rights related concerns? So maybe we can you can think about this and maybe take it up, because I think this is in your handbook, you talk about this, but not in the course. And so if we have a little bit of time. Marva, let me move to you. I think you've seen some of the question. Some of the questions I have here is there any link between labor provision in FTAs and the employment rate? So I've seen quite a number of studies have been shared here, but I don't know whether it's addressing that specific link between labor provision in FTAs and employment rates. And then there is also questions about in absence of good dispute resolution mechanism and the fair system, and it goes back to enforceability, right? Then what's the point of labor provisions, right? So if you have any comments and views on that, but I think you've addressed a little bit of that. So Marva, you've got 2 or 3 minutes if you want. We're over time, but I think it's very useful. Thank you. Yeah,
thank you for that. And I've been working overtime, Jan, in the chat room. The chat room has been extremely absent. I mean, extremely busy. So sorry if I was absent for the last presentation, but I was really working overtime here to answer some of these very interesting questions. I'm really happy to get them. And there was one I didn't answer, so let me get to that one first. And then, no, let me get to the one that you asked first about the employment rate. We do have some research that we try to see how labor provisions can help to support improvement in working conditions. And what do you see as a result of that? And we did find some research, we did find some evidence around improving labor market outcomes for women in particular, improving wages for women in certain sectors, and improving the labor force participation rate for women, which you would expect in a trade agreement framework anyway, but when there are labor provisions over and above that. And one of the reasons we came up with was it could likely be because the labor provisions, really focus on this issue of non-discrimination, and that could raise awareness in some cases for women who are entering the labor market for the very first time. So that in that case, it has some positive results. I wanted to I think I answered many of the questions in the chat, but I wanted to get to this question of Layla, which I didn't answer because it's very good, Layla Ahmad. And her question is, how effective is the dispute settlement mechanism, considering that in the US Guatemala case, the panel delivered its submissions 9 years later after the claimants filed their commissions? And are there other cases that take a shorter period to resolve? And I think this is a good question because it nicely leads me to USMCA and what are some of the changes that the US made as a result of Guatemala. Yes, Guatemala was a failure. 9 years of cooperation, 9 years of dialogue, 9 years of support for the country. I think marriages, there are many that don't last as long as 9 years, and this relationship between US and Guatemala was 9 years long. Stop, start, stop, start. And so some of these issues have been taken into consideration in USMCA, and there are two big ones. One, in terms of the language of the trade agreement. You'll notice in USMCA, which is, for those of you using shorthand, US-Mexico-Canada Trade Agreement, it's called, it's by a different name depending on which region which region you're in or which country you're in. But the first thing was on the language, because the reason why the case failed was because although there were labor violations, they weren't in a manner affecting trade, which was the language that was used for the obligation. So now in USMCA, that's been changed, and the reverse is in fact the case, that you would assume it's in a manner affecting trade unless the defendant can prove otherwise. So that's one change that's been made. The other change in USMCA is the rapid response labor mechanism. And I don't know if you studied this in the context of the course, but this is getting to this not only state to state, but also this state to private, where you can go directly to the facility level and address violations at the facility level between the state and the specific facility. This is only the case in the context of the US and Mexico and Canada. It does not take place between US and Canada, and it's only for facilities in Mexico, in fact. So there was a recent case, the Salao case in Mexico, and it was a much shortened time period in terms of addressing the case, something like 4 months instead of 9 years, from the beginning to the end. There was a complaint put in place. There was an investigation already of the complaint that had to do with trade union elections. Trade union elections took place in a free and fair way, and the case was closed in 4 months. And there was another case that was submitted, but the case, although it was rejected because it was after the trade agreement was put in place, or before the trade agreement was put in place, the parties worked it out because, there's this spillover effect from the previous case that, that now maybe, at the facilities level, these trade agreements mean business. Because if they don't address the case, if they don't address the issue in a short period of time, sanctions can be put in place unilaterally. And that's a first in the context of trade agreements. I could go on, but I'll leave it there. Just for
thank you, Marva. No, I mean, I don't think there's a course. This is really a baseline course on sustainable development provision in RTAs, right? So it's like a level 1. So I don't think it goes into that level of details. Actually, we are planning an advanced course on sustainable development provision in RTAs. So you'll be very welcome, Marva, again in one of the live sessions when we do this. And then actually we are drafting an entire chapter, a very detailed chapter on labor provision in RTAs, building on a lot of studies by ILO. So we'll be sharing this for your review as well. We are a little bit behind in time, but Michelle, I think you've seen a lot of the questions raised in the chat as well. If you want to take the floor and provide your 1 or 2 minutes of feedback, I think maybe given the context, the ASEAN context, I think that would be very useful. Thank you.
Sure. Yeah. So there's one, I mean, it's actually your chat about this observation about how FTA address climate change issue and carbon. I think maybe I'm just short about the environmental concern here. So I mean, I refer to also Paul's presentation at the beginning about how this economic expansion as a result of trade liberalization, how this economic growth actually it's kind of like a coin with two sides. It has a positive and negative effects. Paul refer about exploitation and depletion of natural resources. That's as the negative effect. And also the positive effect, I have to say, this economic growth and also education, also technology, actually it's increased capacity of people to deal with the environment issue more effectively and efficiently. So this is where trade agreement can play important roles. So to address these positive and negative effects. So for like exploitation and the negative effect here, that's why you have this sustainability or environmental related provision, where to ensure that the products that enter into the market, you ensure that, for example, it's not as a result of deforestation. So you want to have those kind of provision in your trade agreement. But at the same time, you also want to have trade agreement that facilitate that positive effects. For example, how you shape or facilitate trade in green goods or environmental or green goods or environmental related goods. So by reducing the tariff, for example, or your commitment to not impose non-tariff measure on that. So this is the trade agreement as a tool, as a means to how to address these positive and negative effects. I mean, that's in my opinion. Thank you.
Okay, thank you very much. I think we are running out of time, so I think we will stop here. I think most of the experts have been answering the question in the chat room, so I think we are quite well covered. I had just had a technical issue with my computer. It's not a good day, so I'm actually speaking from my phone at this point. I hope you can hear me well. On the chat, I mean, there was this question about climate smart regional trade agreements that is coming up, right? So ESCAP with UNEP and with UNCTAD has done an entire new study on this, and so you're all welcome to take a look at this. And this may also be useful for the ASEAN negotiations of the renewed ASEAN free trade agreement, because this is like the labor, right? It's not a matter of whether you need to have labor provision in RTAs. It's a matter of how and when you're going to have those as well. I mean, the European Union is really moving forward with the CBAM, right? Cross-border adjustment mechanisms, and all of this Asian countries need to prepare with. And then one way to do this is through including relevant provision in RTAs going forward. So I will stop here with a huge, giant thank Thanks to Paul, to Marva, and to Michelle. I think you've seen how responsive and active all the participants are, and we're very happy to be developing this trade negotiation capacity and community, and also in collaboration with all of you here. So looking forward to having you again in future courses and live sessions. Thank you very much.
Thanks.
Thank you.
Thanks, everyone.
Bye-bye. And then see you tomorrow for the next live sessions, all the participants.